Hello everyone, good afternoon. Am I audible? Audible, visible? Tell me. Let me have that interaction with them. Technology and its challenges, right? UPSC may ask you this question in your GS3. What are the challenges with respect to the advancement of technology, which we are seeing? Anyways. So, it's a request to all of you, please open up your video camera so that at least I know who are all of you and we can have this interactive session on the first day, right? So today, let's in general talk about law. Let's understand about law and requirements of UPSC. Okay. What's your name?
Suryadeep.
Suryadeep. What's yours? Ayan. Yours?
Kotresh.
Yours? Saina. Richita. So to online students, welcome to Rao's IAS, to all of you as well. Let's understand, what does UPSC require from us? That's most important. So all of you are law students?
Yes, sir.
Online students, all of you are law students or about to pursue law or a law graduate or pursuing law. Anyone who is not from a law background? Okay. So at least I can have this understanding that you have a fair understanding of law, but maybe not for those who have, I think there are some students who have not yet started law, 3 years course. How many of them are there like that? Who plan to join law, like wish to continue for 3 years LLB? Anyone like that? I'm asking you at the outset so that I should understand what sort of communication I need to, I should need to take this class ahead with all of you. No one who is about to start the law? All of you have a decent amount understanding of law, right? Okay, without wasting much of your time, I'm sure you know that this is our syllabus. I think some issues here. Okay. So this is your basic syllabus, all of you, if you can see. Just a basic understanding. I just, on this day one, I don't want to start with hardcore topics like ekdam se shuru kar diya. Let's understand, take this gradually. So as you see in paper one, we have, what we have? Constitutional law. I'm sure you must have studied in your back at colleges. How many of you are not comfortable with constitutional law? Online students, not comfortable with constitutional law? Because you have to be transparent with me. If you are not transparent with me, I will not be able to understand what sort of, how to guide you, how to navigate you with respect to UPSC. At the outset, I must tell you, I'm sure you must have gone through studied in your college, yet the approach, the topics are same, but the approach you will understand is slightly different or would be slightly different, not with respect to the basics, but with respect to the understanding of, right? So in that sense, let's refocus on all these topics. So yes, all good on constitutional law? Say something. Yes, please.
Not updated with constitution after 20.
Not updated. In what sense?
Developments are taken.
Okay. 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 See, as far as constitutional law is concerned, yes, of late, UPSC has started including the element of current relevant events, but at the same time, it's also your basics. So current developments is necessary, but without your basic knowledge, it will not help. Suppose I'll ask you a question on reservation. Let's say a question is asked on reservation. Now, you don't know much about reservation, either with respect to its constitutional history or the landmark judgments, and yet a question is framed on a present judgment. Let's say a judgment came in 2021 or 2022 or 23, but the question has merged the element of current development and your basic element. Yes, current development is necessary, is important, but without your basics, it will not be of any help vis-a-vis the UPSC answers, right? Okay. I think this is revision of essential case laws, difficulties in some concepts. Okay. So yes, there are concepts. In law, please understand this very neatly. In law, there would be, particularly for UPSC, means this is what we are focusing on, right? So in law, of course, there will be concepts, and these concepts are important across papers, be it constitutional law, be it international law, be it contract, be it torts, koi bhi ho. Concepts are important. And every concept need not be there that these concepts are sole concepts. There could be layered meanings of concepts. Concepts having different layered meanings could be possible that, let's say, either these two or this one also forming an exception to such a concept. So from UPSC point of view, we need to understand these layers, different layers of the concept. And then we'll go back to the PYQs, the previous year's questions, to understand that on which concept of any given topic across the sectors or across the subjects, what sort of, what is the demand of UPSC through those questions? And then you'll realize that based on a concept, let's say in international law or torts or in constitutional law, it's not only that the basics of a concept is being taught, but also certain sub-layers, or let's say the branch out of a particular topic. So a concept need to be understood comprehensively, irrespective of the subject attached to it. Correct? I'll give you an example. Let's say if I tell you this, Article 13. All of you know about Article 13? Delegated legislation? No. Doctrine of eclipse. Does the whole Article 13 talks about doctrine of eclipse? Exactly. So this is something which we need to know very clearly. See, law as your optional for UPSC, you have to treat it like a very technical paper, very specific paper. And based on the question, you'll realize what the examiner is asking or demanding is that you are able to separate between these different topics in a crystal clear manner. This is what is required at the outset. And this is how we are going to take our lectures forward with respect to every subject. This is at first. Another thing is that this will be our navigator. Because it is based on the PYQs, we'll understand that what sort of question is UPSC demanding from us, on any given topic. This correlated back with the syllabus. So whenever we'll deal with any topic, we'll deal with the syllabus. I'll make sure that you know the syllabus, you know some of the PYQs, not at the start, but at least to have an idea, considering the fact that at least you have some or a fair amount of knowledge with respect to law, right? It's not that we all are starting from clean slate, at least not for all of you, maybe for some of you. Okay, fine. So in this sense, this correlation is extremely important because it is here you'll try to understand this bridge. So this is the first thing which I would like to tell you first. Any doubts here? Yes, please.
स्पेसिफिक पता होगा वो कोई एग्जांपल उसका आप दे सकते हैं क्या
आर्टिकल 13
सर हाँ तो ये आर्टिकल 13 के एग्जांपल में आपने बोला कि आर्टिकल 13 का मतलब है डॉक्टर में करके तो उसके बाद आपने उनसे पूछा कि उसमें क्या सिर्फ वही आता है तो वो बोल नहीं पाए तो आप बेसिकली कह रहे हैं कि हमें सिर्फ ये नहीं जानना है कि उसमें क्या है क्यों है और क्या क्या नहीं है उसमें स्पेसिफिक मतलब टू द पॉइंट
very simply to answer it. What's your name again?
Surya.
Surya is asking that what exactly we need to know. For example, let's say with respect to Article 13, very clearly what you need to know is the bifurcation between Article 13 Clause 1 and Article 13 Clause 2. Is there a complete bifurcation? And if there is, why? If there is not, why not? Simple. In simple terms, Article 13(1) deals with pre or post constitutional laws. Which one? Those laws which has already been made prior to the commencement of the constitution. This I had already dealt with in your orientation session, right? Some laws, for example, Indian Contract Act, when was it made? 1872?
1872, sir.
1872. So definitely not made after the commencement of the constitution. Commencement of the constitution is which date? 49. Dekho, please understand one thing. Obviously, we'll start constitutional law much later. But please understand this, when we start constitutional law, I'll make you go through the prelims question also. Why? Because the concepts are same. And you'll realize that the kind of depth UPSC has started asking, I'm not only talking about UPSC, the law optional paper, the mains paper, but even your polity section and also your prelims section of polity, right? So we need not only a nuanced understanding, I hope you understand what I'm saying, but also we need to know that crisp point, that point which separates one provision from other. Can anyone tell me, why do we study landmark judgments? Why? What's the need?
They are the precedents.
Precedents. What are precedents? Yes, Saina?
They will interpret the law,
Mhm.
provide
Hmm.
a very, provide a very fundamental insight on.
Fundamental insight, okay. Sources of law. Okay, fair enough. Sources of law. But my question is, again, you are not following my question. You're not answering based on the demand of the question. I am asking, what is the significance of a landmark judgment? Why do we only study landmark judgments or some landmark judgments? Not all of it. There are so many judgments. Law itself, there is no limit to it. That's why students find it hard even to study back at college and even for civil services. But there has to be a fine drawing line. There has to be a boundary, isn't it?
The provider interpretation change the current.
Yes, landmark judgments are essential because at that point in time, when the judgment was delivered, it changed some aspect of the law or some understanding of the law as compared to what was prior. Did Kesav Nanda Bharati judgment in that sense change the very understanding of certain elements of law? What did it change? No, that is a legal part. That is a very mechanical part. It reverses earlier judgment. Of course, it reverses earlier judgment. That's the whole point of it. On what grounds?
In the case of the
See, I don't think a question could be any simpler than this. What did basic structure judgment or the Kesav Nanda Bharati judgment changed? Why it is referred time and again and again and again after more than 50 years when the judgment was delivered?
It imposed limitations of the power of.
Perfect. It imposed limitation on the powers of the parliament, first. Second, through that, it provided a sort of an understanding between fundamental rights and directive principles. This is how you're supposed to write your answers. Not in an elaborated manner, the way generally we write back in our law schools or colleges, but in a very succinct manner, in a very crisp manner, so as to put across your point. I hope I am able to put across my point. What is the requirement of law optional vis-a-vis UPSC? And our focus is strictly UPSC because, again, I'm not here to give you a degree. I'm no scholar. But yes, together we can sail through this process and at least understand what UPSC demands from us. That's my job, to make you understand what UPSC demands from us. And in the process, we abide by the rules, or in that sense, whatever is demanded by UPSC, at least we understand conceptually, analytically, and in these layered meanings. I hope, yes, please.
So are we supposed to elaborate the answer then? Like,
Elaborate, sorry, are we supposed to?
so are we then supposed to elaborate the answer?
Elab.
like specific or बस to the point पे से हो जाएगा.
We'll come to that. We'll come to answer writing. First, content is important. Yes, we need to address the issue. How we need to address the issue comes later. What to write, how to write. See, anyways, either you have a 10 marker question, or you have a 15 marker question, or you have a 20 marker question, max to max. Question number 1 and question number 6 are compulsory, which are 10 marker question. So for 10 marker question, how many pages you get? 2 pages. For 15, 3, right? So this is how the schemes are there. So ultimately, when all of you or some of you are writing the mains, there is nothing known as a best answer. It's always a comparative answer. Let's say Surya is writing something, Sanya is writing something, Anjalika is writing something, Shraddha is writing something. So all of you will be writing the same things, the same points asked by UPSC, but still your answers would differ because of your own understanding. Our job is to bridge that difference, to make sure that most of you or all of you, as far as possible, try to write on the similar lines. Because why? Because at least we will try to understand the concepts in that sense. Talking about concepts, tell me a very basic thing with respect to the difference between law, morals, and justice. Is there any difference? Is there any correlation? How do we see them as?
So,
Yes, sorry.
so the relationship between the three of them is, and according to the case one and the case, like we have a general idea that things need to be in a like they the law needs to be having an alignment with morality and justice. Like a law cannot be immoral, and an example of that, the Article 3.
But it can be. What if the parliament passes such a law?
So, but
Can a parliament pass such a law? Why not? If they have the majority, what do you think? Can the parliament, any parliament, not Indian parliament, can any parliament or any system, political system, having the concept of parliamentary supremacy or parliamentary sovereignty or a parliamentary setup, can they pass a law which, according to some, are not moral? For example, same-sex marriage. Let's say tomorrow, our parliament passes a law on same-sex marriage. Possible that some section of the society still thinks that it's not moral, yet it's a law. So where do you define, is there any defining line, or are there again layered concepts? Now, in those layered concepts, when we study constitutional law particularly, constitutional law generally, obviously will go through the process, the setups, the rights, duties, institutions, organs, etc. But from a law optional perspective, under constitutional law, what we need to know also is with respect to the conflicting issues. Conflict, let's say, between legislature and executive. Conflict, let's say, between executive and judiciary, which we are seeing in the collegium process. At times, the center, since there is no time limit with respect to appointment of judges, so the center can press it down. And we have seen, I'm sure you must be reading the newspapers with respect to collegium. NJSC judgment, another aspect. Or any conflict between citizens per se and the state itself. Let's say with respect to an interpretational understanding of fundamental rights and fundamental duties, which is to be given more weightage. So when we study constitutional law, other than the layered meanings, we'll also try to understand it from various conflicting points and what the Supreme Court judgments or those landmark judgments, how have they tried to sort out this conflicting issue? For example, very recently, the Supreme Court judgment on this controversy between the LG of Delhi and the Chief Minister of Delhi. So there was a conflict, right? And the Supreme Court tried to sort out the conflict, yet the conflict remains. So similarly, there are still conflicts across dimensions with respect to the political spectrum. So that is also something which we need to understand, right? Okay, coming back to I think some of you has. Okay, Angelica has written, law is a rule which exists to govern society. Morality is the sense of right and wrong different to different people. Okay. Justice is the deciding of right and wrong as per the law. Okay, perfect. Very nice articulation of this point. What else? Kritika has written morality is subjective, whereas law is prescribed. Hence, what is immoral is not illegal per se. Yes, not all the time. Morality is subjective. Okay, fair enough. Of course, morality is subjective. And in any given society, please understand this part. When we study law, because law optional, you'll study constitutional law, contract law, mercantile law, law of crimes, law of this, law of that, law of torts, so many laws. So it's important to understand this term itself first. And no law can exist without a society. And no society can exist without its people. So ultimately, it is for the people. Can I say in this regard, to regulate certain aspects of human behavior? Now, this could be either on the civil side or on the criminal side. Can I say this? Let's say law of contract. The whole process of breach of contract, it is regulated by law. So when I say regulate, a law regulates, it means it ensures the enforceability. Can I say this? And how it ensures enforceability? Through sanctions. I'm trying to break down the jurisprudence in a very simple term. So ultimately, now can you correlate the statement of Austin? Law is nothing but a command of the sovereign. I'll just add up words so that your sovereign. Now, what is a sovereign? Who is a sovereign? Who comprises the sovereign? Can we say at least we the people, according to the Constitution of India, provided in the preamble? Now, there are two important elements of any sovereign. They are externally independent, let me know if the spelling is wrong, and internally supreme. In other words, very simply, no other person or institution or a sovereign country or any group of countries or any regional organization can dictate our decision making. Very simply. No, there couldn't be any outside influence unless we want to take certain action by ourselves. Can I say that more or less defines sovereignty? Yes, please. So there is a connection between law, sovereignty, society, and people. Do you agree with this? Don't just see, please understand this. All of us, most of us are law graduates here. Give your reasons. Whatever I'm saying is based on some reason. Let's say you have a different view. Perfect. Air it out. Just say it so that our whole discussions becomes more enriching. Yes, please.
I think
Which one?
after this, how is it associated with it? Like, what does internally supreme mean and what does externally mean?
Internally supreme means there is no other authority but the government of India which can take its own decision, or the government of any state. External sovereignty and internal sovereignty, basically. I've just put it in a different word.
All the countries come.
ठीक है.
No external
Okay, so do you think we being a part of United Nations, we have given away our sovereignty?
There's probably no absolute sovereignty, like in the current global order. It's a idealistic concept.
Yes, anyone from online people? Saina says there is no concept of absolute sovereignty, but what else?
It's a idealistic concept.
It's an idealistic concept. It doesn't exist exactly the way it is studied, the way it is understood. So India being part of UN, are we somewhere diluting our sovereignty? That is the question. What do you think? Could there be a direct answer to this? Answer is both yes and no. Okay. Why? Because we have chosen to be a part of that system. Are we externally independent then?
In our own terms.
In our own terms, we are. Whatever you are studying, let's wait for some time. We'll study under international law. Okay. But yes, countries at times do come together for a greater good. And it is here where this element becomes important. Society. As I was saying about law, any law is with respect to a given society. And it is possible and it is true that all societies change after a certain duration of time. That's why now we have Bharatiya Nyaya Sanhita. Earlier we had Indian Penal Code to reflect these changing parameters. And that's why we have so many amendments, either to reflect changing parameters or to reflect the changing demands or aspiration of the citizens. Correct? And on top of that, there are some certain judgments which enforces these changes, hence landmark judgments, or which changes the law point at any given point. So the point I was mentioning about law was, so very simply, a set of rules. Law can be said of set of rules enforced by certain authority. And if not followed, there are certain elements of sanctions. Same thing is there for international law also. But the question comes of morals and justice. Now see, there are certain elements of morality which coincides with that of law. And the purpose of law is to ensure justice. The purpose of law is to ensure justice. So in that sense, we can say that if we draw a Venn diagram sorts, if this is law, this is morality, then this aim is justice. I'll give you an example. Example being, let's say murder. Can we say murdering someone is both a moral and a legal wrong? Can I say that? Or any offense which involves a moral element, let's say rape. Isn't it a moral crime? Also a legal crime? But all aspects of morality may not be regulated by law. Because when we talk about law, obviously there comes an sanctioning element. Sanction. And hence, that's why I was mentioning about Austin, that law is a command of the sovereign. Now, why sovereign? Because ultimately it's the people who elects their government periodically in a democratic setup. People elects their government. That government is empowered to take decisions. And whenever there is change of government, it signifies the will of the people in that sense. Okay? So we have to understand all our laws, whatever we study, from all of this aspect. From the aspect of justice, from the aspect of morality, and also, of course, from the aspect of law itself. So when I say Contract Act, I give you an example. Let's say, what's the name? Surya ordered pizza from Domino's, for example. But it didn't reach Surya, it reached me. I ate it, but that was already paid by Surya. Can Surya claim compensation from me? One example. I'm just giving.
of the delivery.
One example. So there are different types of example. For example, let's say Surya made a promise to me, sir, I will take you to a movie tonight. I said, okay, theek hai, chalo. But his mother called for some urgent work back home and he couldn't. So he broke his promise. Can I sue him? Friends agreed. चलो आज party करते हैं, कहीं जाते हैं, मतलब let's go somewhere. But they're not able to fulfill that promise. Some of them. Can they sue each other? So different aspects. It's a very interesting proposition. So we need to understand different laws from different perspective. What is that perspective? That perspective is your society. Everything happens in this society or any society. So there is a strong correlation between law and its enforcement, this part, in a society. Question is, what if the society changes? What if the morals of the society changes? What if the laws of the society changes? What if the society itself changes? So law always needs to take care of the changing nature, changing aspect of any society. And that's why when we talk about the Constitution of India in this concept or in this perspective, we always say that our Constitution is very dynamic. Why do we say that? Because there is a process of amendment which accommodates certain aspirations of we the people, right? Hence, most of the laws are certainly malleable. I hope you understand the term malleable. It is accommodative of those changes. Same with BNS, Bharatiya Nyaya Sanhita. Earlier it was IPC. But if you'll ask me what new, yes, there are things new and there are things from the IPC which has also been taken, but new elements have also been added. But from an exam perspective, you need to understand those changes which has taken place, of course, and also the jurisprudence. But the jurisprudence is same, because the very notion or very concept on which, let's say, murder or culpable homicide is done, it is same. It is same in BNS. It is same in same under the IPC. Yes, the procedure might change under the CRPC, but we need not worry about that because that's not part of our syllabus. So we'll try to be strictly as per the syllabus, right? Based on a certain understanding of all of these, right? Any doubts so far?
Excuse me, sir.
Yes, please.
Sir, if we look at the executive in India, sir, there's this Ministry of Law and Justice. So, sir, in India, we have sort of demarcated law and justice. So, why is there a demarcation?
Between?
For example, sir, we have a Ministry of Law and Justice, not simply law. So, why they have demarcated law and justice?
Because the purpose of law is to make justice. And that's why they have named it as law and justice, not only
So, sir,
law.
justice can also not subserve the rule of law. For example, law is there to subserve the rule of law, and justice might not subserve the rule of law, which is a quintessential of law, sir.
See, when we talk about justice, it's a very ideal word. The very basic of it being just, fair, reasonable. Many things come together. And it is here where the guardians or the courts come to the rescue in case any of the rights are infringed. So can you repeat your question, please?
Sir, I'm saying that one of the essentials of law is that it should embody rule of law, which is a concept in constitutional law. Justice, on the other hand, it can also embody rule by law. For example, in certain countries, if there are death sentences by stoning and other means, which sort of embody justice there, but we cannot say that it is a proper law.
See, even in justice, there are elements of morality, right? And that's why when we talk about morals, a term also appears to you as constitutional morality. So the role of judiciary in that sense is to ensure that whatever laws are there, it is interpreted in a proper manner. And it will also depend on what both the disputing sides are referring to. So ultimately, justice, when we talk about it in an ideal sense, it's proper implementation of those laws based on the aspects of fair play, the fact that all persons have to be treated equally, there should not be any arbitrariness, right? That's why we also associate with this concept with the principles of natural justice. You know, are you able to follow?
Yes, sir.
All right. So can we move ahead from here? Any doubts? Are you able to follow whatever we have discussed? It is a very basic of it. There's nothing new. No questions can be asked from here, of course, but at least this will give you a sort of an understanding how to go ahead. Now, coming back, if you want to take a screenshot, please do. Okay, shall we move ahead? Okay, so coming back to the distribution, I'm sure all of you are aware about the distribution. So we have constitutional law, administrative law, international law in your paper 1, and your paper 2 is slightly hefty. Like in terms of the subjects, it has more subjects, but it also gives you a sort of a, you know, in terms of choice, there is more choice under paper 2 as compared to paper 1. What do you think? What's your view in a general sense? While attempting, let's say you have to attempt paper 2, questions from paper 2 and questions from paper 1, where do you think you have more choice? But don't you think it's very bulky? So we need to handle this in a very strategic manner. Yes, yes, of course. But that's what I'm telling you. The strategy is these are your major subjects. Major subjects, but of course, others are also. And this becomes your associated topics, right? So what we will start with our discussion is with this law of contract and mercantile law. Okay. What is the meaning of this term? See, when UPSC says something in its syllabus, it means something. What is the meaning of mercantile law? What law does it also include? It says law of contract and mercantile. Sale of goods. Law of agency itself is a part of contract. So here, mercantile, yeah, it includes Sales of Goods Act and Partnership Act. Okay? So that is something implicit. Do you understand how UPSC plays with our mind? This is what happens in the questions also. We read something else, think something else, write something else. So there has to be a consensus ad idem. What does it mean? Is it necessary even to enter into a contract? Consensus ad idem? Meeting of the minds, right? Two contracting parties, two agreeing parties should agree on the same thing in the same sense, in the same manner, right? Let's say if two negotiating parties are there and one believing that he has to send the goods, let's say by post, the other believing that not by post, but by some other modes of communication. So there is no meeting of mind as such. Then you have to determine that whether this meeting of mind itself was relevant, necessary or not, right? So in the entire contract, when we'll study, this is the key. Communication. Communication of thoughts, communication of ideas, communications of proposals, any sort of communication from one end of the spectrum to the other end of the spectrum. From the proposer to the other person. What he or she is called? Proposee. Okay. Communication is the key to any form of contract. When I say contract, I'm going way too far. There are a lot of things which comes prior. We'll come to that. So in general, this is important. Communication is important. So you also need to understand the question, the way it is asked, why it is asked, and what needs to be delivered. So there also has to be consensus ad idem between you and UPSC when you are looking at the papers. Because papers, the nature of the questions could be either explicit or implicit. Very clearly, TK, this is what they are asking, but not in certain questions, not very clear what they are trying to ask actually. Right? Any doubts here with respect to how we'll be going? We'll be going with this first. This section, I'll write it here. So that it's clear to you. First, this. Followed by, see, what has the syllabus provided? Law of crimes. If you go through the syllabus properly. Followed by, of course, third. Now, there is a correlation between this and this. If I ask you that in India, do we follow law of torts? Why? But in England also, there is no legislation for it.
That's what we have a legislation for it, but we do follow the principle.
How? How do we follow the principle of torts? How do we follow that? Do we have a specific law? In India, I'm talking about. In India, what is the current situation of law of torts? Anyone? Common law. What is common law? Okay, as developed in the UK. Fair enough. If I say this statement, don't just agree with me, think about it. I'm making a statement saying, I'll write it down in fact. Most of the elements of law of torts, most of it, not all of it, most of the elements of law of torts is subsumed within law of crimes. Do you agree? Yes. Why? No. Why not? Do you agree with this kind of proposition which I am making here? Either most or some. Yes, online students? Principles are enshrined under IPC. Such as? Negligence, defamation, what else? I'll write it here. Just tell me. Negligence, defamation. Okay, trespass. Sorry. Mischief. What else? Why not? Go on. Do you understand why I was mentioning about this? What else? Now on defamation, we also have a separate law in this country. Because defamation are of two types, criminal and civil. Right? Sorry, criminal and civil. Right. Thank you. So, see, when we talk about torts, what is torts? Civil wrong, in a simple term. I'm not trying to complicate anything today. I'm just trying to give you a very basic overview of the entire subject. Let's not study anything directly. Volenti non fit injuria, as Angelica said. What is the meaning of volenti non fit injuria? Yes, Angelica? Can you elaborate on that?
Sir, am I audible?
Yes, you're audible.
So, sir, as per my understanding, this principle states that if a person has agreed to a certain event, then they cannot hold the other person liable if they suffer some sort of hurt.
Okay. So there are certain legal maxims also which we need to study. Anyone else who can elaborate further on the legal maxim, volenti non fit injuria? It has two elements, injury and act. Correct? So based on this, we'll try to understand. So at least do you agree that some of the elements of torts, when we study with respect to India, are also covered under law of crimes, but yet we need to study it separately because yeah, we study it as a civil wrong. See, I'm not saying it's not a civil wrong. Of course, it's a civil wrong. That's how we study it. But UPSC, any fine day, can come back to you and ask this question that don't you think most of the elements of tortious liability or law of torts are also covered under Indian criminal laws? Elucidate, discuss, whatever. So this, again, this basic understanding is necessary. Of course, we'll study torts as a separate topic. But even while going through crime, law of crimes, we'll also try to highlight some aspect which we will be looking into from the perspective of law of torts. For example, the very famous case of Ryland versus Fletcher. I'm sure all of you must be aware with this case. Okay. It's a landmark case. No problem. What's your name? Ayan. So far, are you facing any difficulty in terms of understanding? Okay. So it's a landmark case of which principle? Strict liability or absolute liability? Strict liability. In simple terms, it says that if you're doing something in your property, let's say this is my property, I'm doing something, then it should not harm the other person's property or my neighbor's property. Let's say I'm digging the ground for making a well. And what happens while digging this ground? The water broke into and flooded the other person's plot or land. I am responsible then, right? So this is the concept. This is the basic concept of which one? Strict liability or absolute liability? Strict liability. But there are certain exceptions. But in absolute liability, there are no exceptions. And that we have to understand from the perspective of environmental jurisprudence as developed in India. Now, this was the exact question asked by UPSC in your GS2, not law optional. GS2, this one. And that too, in GS2, cases were asked. That elaborate on the cases. Go through the question, I think, of 2022 or something. So are you able to connect those dots? So law is not a mere mechanical subject. Yes, while answering the question, we have to, apply your brain and write mechanically in the sense the way the questions are framed, but definitely there is a logical connect, right? So do you agree with this statement that some elements but are subsumed within law of crime, yet we have to study law of torts separately as a civil wrong? This is in a very simple term. This refers to civil wrong. Saila, tell me this. Why do you think law of torts developed differently in England and could not develop the way it developed in England in India? What could be the reason? There must be some reason, right? We couldn't develop that kind of a jurisprudence which is there in Britain or in England. Anyone from the, yes, please. Yes, Surya.
That like when India got its freedom, many people agreed that, many nations agreed that India was not ready for a proper democracy because most of the people were illiterate and uneducated. Now, enforcing that amount of rules on a population of our size it is no small joke at all. So not everything could be covered that time.
Okay.
But even after that, the reason why it's not been, as of yet, it's been enforced is because, like, sir, the parliament is not up to date with the.
If I ask you in a very crisp manner, anyone? Crisp manner. Let's say this question is asked in your UPSC exam. Why do you think law of torts did not develop in India the way it developed in England? Don't you think this is a valid question? Because when we talk about torts, let's say even in India, as you can see, most of it, or some of it at least, are found in some offenses, either under IPC or some other statutory offenses. Yes? Yeah. Absolutely. That is the point. There is a difference in terms of our society. Now, are you able to connect law and society? Okay. Okay, due implementation of IPC since 1860, which comprised the tortious concepts. Okay, yeah, of course, that is being one of them, that most of this has been included here. Huh.
There is a lot of privacy that is given to private property, protection of private property.
Yes, yes.
And individual.
Yeah.
And to the body of the individual.
Correct.
Whereas there is not a lot of importance because
it's not dealt in the same way, the way it is dealt here. Correct. I'm just writing this term. I hope all of you can see. Do you know what is this? What is it?
Magna Carta.
What is Magna Carta?
The Magna Carta was like the adoption of a lot of laws in UK.
Mm-hmm. When did it came into being?
It gave a lot of power to the people.
Way back, 1200s. But what is Magna Carta? Declaration of rights and duties for citizens. Can be associated with rule of law, yes. Sort of a bill of rights. 1200. When did American Declaration of Independence happen? Or, sorry, when the American Constitution came into effect? Around 1770s, 1776. This is around 1200s. 1215 or 18, somewhere around. America, 1776, and we are in 1950. Do you understand the difference in terms of society? That is it. And based on this, also, when we'll go back to constitutional law, this is where we will start with. That why did we follow parliamentary supremacy? And why not presidential system? Now, this was also debated in the Constituent Assembly. And obviously, different, great minds offer different reasons, but ultimately parliamentary the parliamentary setup. I don't want to say parliamentary supremacy, that would be a wrong word, because in India we have constitutional supremacy, not parliamentary supremacy, but yet a parliamentary form of government was decided. So yes, the society also plays an important role in to ensure the kind of laws we have. Don't you think, as a country, as a nation, since 1950, in the last 75 odd years or 78 odd years, we have matured, we have developed as not only as a society, but also as a political setup in that sense, isn't it? So all of this comes along when we go through different subjects, different chapters in those subjects. So I hope I have given you a decent backdrop to law as your optional subject, and it is not, it's not a very dry subject in that sense. कि भाई बस just go through the provisions, just go through the sections. Every provision, every section has a meaning. Every section can be correlated back to the various functionings of the society and its people. And this is what we will understand when we'll start dealing with mercantile law. Let's say Sales of Goods Act or any law which deals mostly with the commercial aspect, the commercial dealings, isn't it? There are other laws for commercial dealings as well. Those nuanced laws such as SEBI laws, such as company law, FEMA, etc., etc. बहुत सारे. But from my exam perspective, let's focus on the law of contract, right? Now, in that sense also, one more thing, before entering into law of contract, since we are talking about Magna Carta and law of torts and everything, you all know that in England, there is no written constitution. Okay? But in India, we do have a written constitution. What difference do you think has this made to our country? Has a written constitution helped our overall development of the society? How? In other words, what if we also followed on the same lines of Britain, and rather than having a written constitution, we also, went for an unwritten constitution? Does Britain have a constitution, first of all?
It has an unwritten constitution. Like it has a constitution. But there is constitutionalism, but there is no constitution.
Another term coming, constitutionalism. The question is very simple. Does Britain have a constitution? Like we have a written constitution of India. Okay?
Yes, it does.
What's your name?
Amog.
Amog. What's it? Yes. What are you saying? Unwritten. Hai. Matlab, come on, it's not unwritten means it's not being written. Then what is that constitution?
An unwritten constitution.
Sir, it is the spirit of the constitution that is in place.
Huh. So where do we find that spirit?
So in case
Hmm.
it's the laws that are made by the parliament.
Yes. Yes.
Because we have a written constitution in India, just
Hmm.
like the US, it gives a lot of power to the constitutional court
Hmm.
because we have judicial.
Hmm.
So that is why we don't have which acts as a check on the parliament's power. Like it's not supreme in our country.
See, when we say they have a unwritten constitution, or they don't have a written constitution, so there are things which they consider as part of the constitutional setup, which includes legislations made by parliament, which includes various judgments, which includes various customary laws, customs. Is custom part of our law?
Parliament.
Let's say this question is asked in your prelims examination. Is customs part of our laws according to the Constitution of India?
Yes.
30.
Yes, Article 30. The same concept you'll study in international law also. Is customary international law major part of international law? Yes. And what does Article 13 says? Those custom which has the force of law. Why force of law? Because we believe that it is legally enforceable. Right? So in England, there is nothing as such a one document. There is no book as such known as the Constitution of Britain or Constitution of England, but different aspects like the judgments which acts as precedents, various conventions, some customs, those legislations, all of it collectively is referred as the Constitution of England. Now they are also in the process, or I think they have formulated a committee in Britain where they're also thinking now to have a written constitution, but so far they don't have one, like we have, or like America, or like France. Okay, right. So, okay, moving further from here, coming back to our topic on contract. Now let's start law of contract. How many of you have studied in your college? कितने अच्छे से पढ़ा है? Sorry to ask this, but I have to. Because if you have studied it properly, then I can rush through. What do you think? Pass only like. Don't worry, we all used to do the same. Anyone from the online students? First sem, first subject, sir. Okay. Did you follow much of it? Some part in CS course, yes, you have told. So, didn't get much of it. Okay, interesting. So need to be studied properly. Section 1 to 75 is relatively easy. Do you remember all of the sections? Vaishnavi? Okay, take it. Sure. Let's now, of course, it's not important to just do a rote learning. You may remember it, but what is more important is that do you understand it? That has to be the correct question. It's not that whether you have read it, whether you have learned it, whether you are aware of it. Whether do you understand? There's a difference between knowing and understanding. Knowing could be like, yes, I know कि आज newspaper आया है. I know that. But have I read it? No. Have you read it? Have you read today's newspaper? Newspaper reading is also important. Okay. So this is your syllabus. Very simply, let's try to boil down again on absolute basics. It says nature and formation of a contract or e-contracts. Now, e-contracts are nothing but, with the advent of technology, we are also having contracts. Sender and the acceptor are, on internet, and they're sending those e-contracts through internet. That's all. Can you tell me the legislation which is governing e-contract presently in the country? IT Act, Information Technology Act. Yeah. Factors vitiating free consent. Now, this is important. Now, this is what your syllabus says. First says nature and formation of contract or e-contracts. Factors vitiating free consent. So at least we can understand that this is an important part of any contract, free consent. In other words, it also means that consent cannot be forced. In a very simple word, I am just trying to break it down. Can I say this? Unless the other person wants. Forced means, what does the word forced here signify? It signifies unwillingness. Can I say this? Please understand here. Can I say, I was not willing to do this. Someone put a gun at my head. Karo, varna, I'll shoot you. Bhai, I had to sign. Whatever documents the other person wanted me to sign, or any other person. You understand now? Free consent. Very important terms, 3 important terms: void, voidable, and illegal. So these are the 3 important terms highlighted in your syllabus. What is the first term? Void. Very simply, the meaning of void is that anything not supported by law. Just write it down. Anything not supported by law. Okay? We'll come to the provisions. I'll give you an example. Not supported by law. Let's say me and Surya made an agreement to kill some other person. Valid?
So I think it depends who you and I are. Yes, sir.
Whom do we want to kill?
So if you're the PM and I'm an
Doesn't matter.
army general,
Doesn't matter.
if it's a war, then
Let's not take exceptional circumstances. Let's talk about our society. What did I say? Law. We have to study in the present society. Now, a few days back, Dr. Subba Rao visited Rao's IAS, and we were discussing number of things, and we asked some aspects regarding to economy, his views on certain things. Other than the academic part, he mentioned that, see, society change, and some beliefs which we held at that point of time, it's possible that those things may not be relevant or applicable in the present circumstances, right? So we also need to understand this aspect in a changing society. Nevertheless, let's keep this in a normal society, and let's not try to incorporate some extra element. What you're saying, that's a totally different thing. That even does not come within the aspect of contract. My simple question to you is that, can two persons enter into a contract for killing a third person? Is that contract valid in law? Agreement तो आप कर सकते हो आपस में. You can do it among yourself. But is it valid in the eyes of law? So any contract has to be valid in the eyes of law. Surya, you made me the PM and yourself the Army General.
It's an opinion, sir.
Right? The second term is voidable. Now, voidable, in a very simple term, any agreement, there are two parties, let's say A and B. So in a very generic term, generic way, the most simplest of the ways, voidable means either A or B can opt out of the agreement. As simple as that. Voidable means either A or B can opt out of the agreement. Simple. As of now, bas itna samajh lo. Then unenforceable agreements. Those agreements which cannot be enforced. Have you ever gone through doctrine of frustration? Something which cannot be done. Then performance and discharge of contract. Now, can I say that when two parties, let's say A and B, enter into any contract, then it's not mere contract, but there are number of rights and obligations which arises out of it. Can I say that? For both parties? Okay. So these performance or discharge of contract also create certain obligations for either part, which they are bound to do or not bound to do if they agree on such lines, either to act or abstain from doing that act, that is action or commission or omission. Okay. So let's, in our first leg, let's understand these parts. Are you clear with the syllabus? What does the syllabus, or how does the syllabus want you to understand contract as? Syllabus wants you to understand contract in a very simple term. Can you tell me where the contract is the end game? Contract pe everything ends. Where does it start? Where does contract start? I'll write it down. Don't worry. Offer, agreement, what else? Acceptance. What else?
So consideration.
Consideration. Where does it start? Again, you're not following the question of UPSC. Where does the contract start? Offer. Anything else? So there has to be an offer from a person, right? To whom? To other person, to other party. Offer made. Let's say this is done by A. This is to be done to B. वो तो, he will be called the offerer and B will be called the offeree. That's it. Nothing more. What else? So when does this offer in legal terms also referred as proposal. That's why the word proposer or the word offerer. Okay, I don't want to go into the grammar of it. Proposal. So a proposal is given to B. What he'll do? Either accept it or reject it. So proposal, when accepted, what does it become? No. Perfect. It becomes a promise. I'll make you go through the definitions, don't worry. पहले ये समझ. Understand the steps. Then it will be easier to follow the definitions because it will be again mere reading Latin. Proposal, A proposed B, do anything to buy a piece of land, let's say. B said, ठीक है. On what basis? B might have said yes or no on certain basis, right? Let's say both of them are, trying to enter into a contract to sell. A is trying to sell a piece of plot or land. Let's say there is a very premium plot in Delhi, anywhere, Mumbai. A is planning to sell it to B. So he has offered B. खरीदोगे? Will you buy? What will B say? Yes or no? सीधा. Is there anything in between which can come? Rust?
So he might ask for the value of plot.
Perfect. He will ask the value of the plot. देखो. When you understand laws within the societal framework, you'll understand it better. यही अगर मैं आपको, if I'll make you go through the sections, we will go through it, but you will not have this kind of a clarity. So of course, we will ask the price. This price technically is also referred as consideration. And the understanding of consideration is on the basis of quid pro quo. I'll repeat. Price can be said to be as consideration. Let's say A says, I want to sell this plot of land for rupees 1 lakhs. That's it. 1 lakh. B says, no, you're quoting much higher price, not more than 80,000. Suppose. Now either A agrees or disagree. Or A again say, no, 80,000 is too less. Let's make it 90,000. Na tumhara, na mera. Neither yours nor mine. B says, okay, fine. I'm dealing with number of concepts here. Counter offer as well. Okay? So consideration is this price. And in consideration, there is something in return for something. What is A getting? No, money. A is getting money. He's selling land. What is B getting? Land for what? That money. So both of them are exchanging something or one for the other. That is what is consideration. There has to be a quid pro quo or something for something. Or in a simpler word, reciprocity. Okay? So far, so good. Proposal made to B. Then if B agrees, then it becomes a promise. This promise further results into an agreement. Now they agree. B agrees. ठीक है. I agree on 90,000. Agreement is based on something. And when this agreement is enforceable by law, it becomes a contract. And this agreement is enforceable by law, it becomes a contract. Do you understand this?
Sir, I have a doubt.
Yes, please.
Sir, there is another important element, that is the intention to enter into a legal relationship. So
That will come. That will come. Of course, there is. Then we come to what are the ingredients necessary. I'm just giving you an example and trying to make you understand how all of this comes into picture.
okay.
Of course, there is intention. But are you able to follow this sequence? Proposal, promise, agreement, contract. Here. हाँ, sorry. इसके बाद acceptance. Based on acceptance, you have your agreement. And that agreement, when enforceable by law, becomes a
Sir,
contract.
so for A, the consideration would be the piece of land, and for B, the consideration would be the money.
No, it's the reverse.
Oh.
It's just the reverse.
Okay. So what the person is receiving, that is the consideration.
Yes. Yes. This is a very, very generic example. Now, let's try to go through some important constituents of contract. But do you understand that it's not contract? It does not start with the contract. It starts with the offer. Now, an offer can be of different types. Specific offer, me A offering specifically to B, or A making a very general offer or offer to the public at large. Right? There are different types of offer. We'll come to each of it. We'll come to every element, offer, agreement, acceptance, consideration. We'll come to each of it. I'm just trying to break these down so that we have some clarity, at least on day one. Nothing more. Is this clear? So now it says that all agreements are contracts if they are made by. Do you agree with this? Right now, I'm not taking you to sections. Let's understand the concepts of it first. Then we'll go through the sections. Before going through the sections, we'll also go through the questions asked by UPSC. Free consent of parties. Do you agree? It has to be free consent. In that example of A selling his land to B cannot be forced or coerced. So the word here is coercion. There has to be no coercion. Undue influence. Parties are competent to contract. What is the meaning of this term? Parties being competent to contract.
Both the parties are majority of above the age of 18.
Above the age of 18.
And of sound.
Tell me this. Is the age of majority same for entering into a contract and also for marriage? And also for voting?
Yes, sir.
Same.
Sir, under the
Research
Hindu
about
Marriage Act, the age for the girl is 21 and for the boy is 18.
So it's not same, no?
Yes.
You understand what I'm asking? Is it same? No. Okay. Competent to contract, of course, of sound mind, and also that these people do not suffer any infirmity in the eyes of law. Can a person who is incarcerated or who is in prison enter into a contract? Do a research on this. Can a person who is incarcerated or in prison, can he or she enter into a contract? As of now, I'm just laying the basic foundations with respect to contract. so that you all get a solid understanding about not only the concepts, but I'll also make you go through the questions so that at least you are aware that whatever we are dealing with, why we are dealing with in this manner. Then it says considerations, see the term, are lawful. And I've told you anything which is illegal. Now, what is illegal? What is the meaning of the term illegal?
Something which is not permitted according to the law of the
Okay,
land.
not permitted according to the laws. Perfect. So considerations are to be lawful. With a lawful object, that is the purpose of the contract has to be lawful as well. Like I cannot enter into contract with any other person for smuggling activities. Why? Smuggling activities. Is it a lawful object? No. And not expressly declared by law to be void. If law outrightly highlights it to be void, what it will be? A void agreement. Is it clear now? Void and voidable?
Sir.
Yeah.
Sir, so basically in the last slide, we learned the essentials, how an agreement is made. And in this slide, when does an agreement becomes a contract? These are the 5 essentials.
Yes, yes, yes. All agreements are contract. See, this is the question which UPSC has asked, that all agreements are contract, but all contracts are not agreement. This is the question asked by UPSC. Is it any, do you finding it anything difficult to understand so far? Just let me know in case you do.
Sir, can you repeat that part where we were talking about the parties competent to contract, the age part?
I'll repeat.
Yes.
I'll repeat that part. Don't worry. Voidable. Void is anything which is not supported by law, or which the law itself declares to be an illegal act or a criminal activity. Something prohibited by law. At least you understand this? So any agreement on certain things which is prohibited by law. For example, I gave you that example of smuggling. But me entering into an agreement with someone for smuggling of gold. Is it a valid? No, it's not a valid contract. Now, what is the difference between these two when we say agreements and contracts? So I've already told that an agreement only becomes a contract when it is enforceable by law. So there is a sanctioning element of law or having a validity in the eyes of the law. So there could be an agreement, let's say between two parties on a number of things, but it's possible that some of those things are not supported by law, right? Is these 5 points clear? You told me to competency of the contract. This is what you told?
Yes,
Asked.
sir. Yes, sir. Yes.
See, competency of the contract means those parties, whoever those parties are, could be a person, could be an institution, could be a group of persons, whether in this country or in India, since we are talking about Indian Contract Act, whether they are competent to contract, or the fact that whether they are not having any infirmity in the eyes of law. They are legal persons or citizens. Both of them can enter into a contract. Okay? They do not have any legal defect per se. For example, if a court has issued an injunction saying that this person cannot go outside India, suppose, and he makes some contract on those lines, or let's say a court has highlighted some issues with respect to a corporation and told the corporation not to enter into future agreements on this ground, on a particular ground, then of course on that ground, that institution or that corporation could not enter into an agreement. So that is competency to contract.
What if a 16-year-old boy goes to a bicycle shop and gets a bicycle for himself? And once he comes out, he gets to know that the cycle is broken. Some part is broken. Now, is it a valid contract? Like, is the agreement whatever he has done?
technically not. But there would be some exceptions when we deal with agreements by minor. Okay. Yes, Vidi.
So when we talk about considerations are lawful, that aspect of it, then do we mean that the exchange that happens in the process of the contract has to be legal?
Yes, yes. That also. That also.
Okay,
We'll
so
come to it. We'll come to each of these are separate chapters itself. Proposal, agreement, acceptance. All of these are considerations. All of these are separate chapters. And
got it.
today we are just trying to understand these in a very nutshell manner, or in a certain comprehensive manner. Just giving you an outlook. But yes, what you have asked, that is true. Okay, this is your Section 2 of the Indian Contract Act. Let's go through some of the definitions with whatever we have discussed so far. So Section 2A says that when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of the other to such act or abstinence, he says to make a proposal. Now, this is a slightly technical word. Go through it properly. And again, let's understand again. When a person signifies to another, let's say A signifies to B, his willingness. What is the meaning of the word willingness here?
Free consent.
His intent, his declaration. In other word or in contractual word, he's communicating also. His willingness to do or abstain from doing anything, that is commission or omission, with a view to obtaining the assent or acceptance of the other person to such act or abstinence, he said to make a proposal. Is this definition clear? 2A. I think this is what we discussed. But this term here, his willingness becomes important. Moving further, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So when the person to whom the proposal is made signifies his assent. What is the meaning of the word signifies? Same, communicate. So as you can see, communication is the key to any contract. Now this statement could be asked as one of your questions. Examine or discuss. The proposal is said to be accepted, and a proposal when accepted becomes a when he accepts it, it becomes a promise. So what is a promise? A promise is a proposal when it has been accepted by the other party. The person making the proposal is called promiser, and the person accepting the proposal is called promisee. Now, before, in this example, ये था, ये वाला था. This one. So in this example, till the time B has not accepted, he was the proposee. And when B has accepted it, he becomes a promisee. Okay? Two D says that when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act or abstinence or promise is called consideration for the promise. Go through this again. When at the desire of the promiser, that is A, the promisee, that is B, or any other person has done or abstained from doing something, So at the desire of the promisor to sell the plot of land, the promisee or any other person has done. He has agreed, has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called consideration for the promise. So consideration is always in relation with promise. And what is a promise? When the proposal is accepted. When it is accepted, it becomes a promise. The question is, can a promise be held accountable in a court of law? Or can only a contract be held accountable in a court of law? Is it clear? What? Till the stage of promise, is it enforceable in a court of law? No. So this is also something which we need to look into. This element of promise. This is a very important part of contractual obligations and liabilities. Any doubts here so far in the definition part? Moving further, it then says every promise and every set of promises forming consideration for each other is an agreement.
Sorry, sir, I have a doubt.
Yes, please.
In clause D, could you please go back?
Yes, please.
In clause D, what is the significance of promisee or any other person? What does the any other person mean here? That's
Any
my
other
doubt.
person means any other person to whom that promise has been made. Could be a group of persons.
So won't they then become the promisee as well?
Yes, please.
So won't they be called the promisee then?
Promisee or any other person has done. They will be called promisee if, see, if there are any other persons, I think they will also be called promisee in that sense. Once they accept it.
Okay.
We'll deal with it. When we'll take up the chapter on consideration, we'll deal with, there are many, again, I've told you, there are many layers to it. It's just the mere definition. And there will be number of cases also. Okay. Just making you go through these definitions so that you understand that how these definitions helps us to understand, build our concept. So what is an agreement? Every promise and every set of promises forming the consideration for each other. Every promise and every set of promises forming considerations for each other. So there is an element of reciprocity here as well. Is an agreement. And promises which form the consideration or part of the consideration for each other are called reciprocal promises. We'll deal with this separately. Don't worry. Now look into this. This one says that an agreement not enforceable by law is said to be void. Simple. An agreement not enforced, which cannot be enforced by law, is void. Simple, straight away. Agreement in restraint of trade, what is it? Is it void or voidable? What do you think?
It's a void.
Void. Why it is void? Think about this. Why it is void? Yes, we know it's void. Then it says an agreement enforceable by law is a contract. Very straightforward. But as you have seen that an agreement, reaching an agreement, there are a number of things. From proposal to willingness, to other person accepting it, becoming a promise, promising resulting in based on consideration, that resulting into an agreement when enforceable by law, then it becomes a contract. So contract is the culmination point, which starts with a proposal or an offer. So there is a long chain, and this is something which we need to understand also. An agreement which is enforceable, next one says, 2I says, an agreement which is enforceable by law, at the option of one or more of the parties thereto, but not at the option of the other, is a voidable contract. So the other person has an option to come out of the contract. We'll deal with it again. I'm just, as of now, we're trying to understand it on a very rudimentary level, very basic level. So what is the basic difference between void and voidable? Can you tell me?
Sir, so basically the when we say an agreement is void, the law declares it to be void. Matlab, that agreement is not permitted by law to be valid. And in case of voidable, we can get it declared void through the court by if one of the parties approach the court.
What is that again? What is that line of difference between void and voidable? Are all voidable contracts void?
No, sir. If they are not declared void, they will be valid contracts.
Yes. So voidable contracts are such contracts where there is an option for the party to come out of the contract. And in case they come out of the contract, it will not be treated as a breach of the contract or not fulfilling the conditions of the contract in a very simpler term. So there are terms which are co-associated with number of other terms. That's all I wanted to highlight for today so that the basics are clear. And last one says, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Simple. I think it's the same thing, more or less. A contract which ceases to be enforceable by law, let's say it was earlier, but later it ceases to be enforceable by law, becomes void when it ceases to be enforceable. So in a society, let's say something was not a crime, then it became a crime. Then on that point, you cannot enter into a contract. Okay, some technical words so far. Finding it interesting? Yes, Article 19(1)(g), right, Man? Man, you are able to follow?
Yes, sir, absolutely. Yeah.
Okay. For your basic understanding, I've just divided so that you know these are the chapters. Now, chapter 7 and chapter 11 is missing. If you see this chapterization. So that's how we will also go through chapter wise. But at times it will be possible or it will be required that we have to look into different parts. So this part is understanding of these parts are important. As of now, of course, we are here. Which talks about what? Communication, acceptance, revocation of proposals. Abhi wo proposal mein hi hai. Don't worry, I'll share this slide with you. So whatever I think I have discussed, I've also talked about certain elements about agreement, some about performance, but ultimately proposal and its communication and its revocation, both communication and revocation. Because in both of this, it has to be communicated to the other side. When it is communicated, how it is communicated. Are the laws similar in India and England? All these we need to understand. So in the next lecture, we'll start with general offer. What is a general offer? Or offer made to the general public. And we'll try to incorporate what happens when a general offer is made. Some case laws and also some examples. Some of the provisions. And then, of course, acceptance and revocation. Now, this is a very important part, revocation part. It's possible that I think it will need one lecture, complete 2 hours, to make you understand about revocation. Then we have of contracts, voidable contracts and void agreements. Okay. So again, we need to differentiate between different types of contracts. What does the law say on it? Contingent. What is the meaning of this term? Contingent contract. Can you give an example?
Insurance.
Insurance. What is the meaning of contingent?
Dependent upon a condition.
On the happening of a certain event.
On the happening or non-happening of something.
Yeah. Only when situation rises. Perfect. So you understand what type of contingent contracts may be. Say, performance of contracts. certain relations resembling those created by contract, of consequences of breach of contract, of indemnity and guarantee, bailment, agency. What is bailment? Can you give me an example of bailment?
So bailment is defined in section 100 and
Meaning kya? What does it mean?
so it's the delivery of goods for a certain task after which the
It has to be
goods are
returned.
not ordered for,
Yeah.
according to the contract.
No, right. An agency. So chapter 7 earlier, as you can see, 6 ke baad 8. 7 was sales of goods. Now it's a different legislation, Sales of Goods Act, and 11 was partnership. So which is another different legislation. Is this bifurcation, chapterization, does it help you in some way to make you understand where we are right now? We are here. Abhi. Let's go through some of the questions. (2023) says, question was, the law of contract is not the whole law of agreements, nor is it the whole law of obligations. It is the law of those agreements which create obligations. As I've told, that any contract, it creates both rights and obligations. And those obligations which have their source in agreement. Don't you think they're focusing on absolute basics? Some critically examine this statement. But to write this, we need more lectures. I'm just trying to make you understand that, see, the question is asked on absolute basics. All that you have to do is to break this question and try to answer this. Can you explain me what this question is asking, Saina?
It's basically a question on what exactly the scope of Indian Contract Act. Does it govern essentially all types of agreements, or does it only give certain basic principles on what is a valid contract or what is not, what doesn't constitute a valid contract?
Okay. Anyone?
Skeleton.
Skeleton. Anyone else? What is this question explaining, or what is it
Yeah.
asking?
Sir,
please.
basically, it is talking about the agreements and contracts. So all agreements are not contracts. For example, if I do an illegal agreement and with somebody, and there are obligations arising for me and the other party, but that those obligations cannot be said to be legal obligations per se.
Okay.
So
yeah, yes, please. Go ahead.
so basically, it is talking about the difference between what is an agreement and a contract.
So is it hinting towards the key ingredients as to what makes a contract enforceable before a court of law? The essential ingredients? Because
Not only that, yes, not only that, of course, but also see the first statement. Law of contract is not the whole law of agreements, nor is the whole law of obligations. So it involves both. It is focusing on these two elements. What are the obligations which arises because of contract? And as it says, contract is not whole law of agreements, because mere agreements and all agreements are not contract unless it is enforced by law in that sense. So it's a slightly complicated question in that sense. So to answer this, you have to understand the whole, what we understood today from proposal till contract, this whole chain, and understand properly that what is the exact point at which contract initiates or starts, and what sort of obligation does this contractual relation ensures or arises, and what are the remedies as well. It then says, it is not mere whole law of agreements or obligations. It is the law of those agreements which create obligations, and those obligations which have their source in agreements. Technically, everything, whatever we have discussed. But can you say to be a very direct question? No, it's not. But this question is very direct question. All the contracts are agreements, but all agreements are not contracts. Elucidate. At least you have something to write about there. So UPSC is focusing on absolute basics, and it wants to test how, or in what sort of manner have you understood the very basic of all the concepts? Simple, nothing more. Right? Again, 2019 law of contracts is not the whole law of agreements, nor it is the whole law of obligations, but it also deals with the rights and obligations of both illicit. Don't you think these are repeated questions? In some manner, in certain way. Exactly repetition to nahi hoga, but they won't be exactly repeated, but like similar. Right? So is UPSC asking any like out of the way question? Something which can't be attempted? What do you think? This one is on e-contract. We'll deal it later. Minority. Okay, then it's this one. Let's go through this. An offer is to an acceptance what a lighted matchstick is to a train of gunpowder. It produces something which cannot be recalled or undone. Answer. Explain. What does it mean?
Sir, so basically it means that when an offer has been accepted, the person has to fulfill the obligations that have been laid down under the offer. He cannot say that I want to revoke my offer after it has been accepted by the other party.
Yes, yes. So it creates a bunch of obligations. It starts creating a bunch of obligations. Once you have put an offer out there and it has been accepted by the public, you cannot then, revoke it. So every set or every step, certain rights and obligations are being created in a contractual capacity or in some capacity. So what are these obligations? At proposal, let's say if it is not accepted, then fine. But what if it is accepted? And it has been reverted back to you. You also accept it. And it is agreeable under the eyes of law. So it creates a contract, right? And this one is law related minors. We'll deal it later. So UPSC is trying to know whether you have studied properly or not. As simple as that.
But what if the contract is voidable, then it can be.
वो पूछ ही रहा है नहीं, that they are not asking that. Focus on what is being asked. Because anyways, you won't have much time nor much space to write. If it is asking about something else, you can't write about some other thing. Okay. So I hope I've given you some clarity, not only about law of contract, but also law in general. Any doubts which you want to ask?
Sir,
Yes, yes.
sir, I don't have a doubt. I generally want to ask what will be our timeline for the plan, how we will be covering the subjects in how much time and in how much lectures.
See, we'll start with contract, followed by criminal law, not IPC. IPC exists no more. Followed by torts. This we intend to cover by it's July, August, September, mostly by mid-October, right? And from there we'll start with some elements of CLD. Then from mid-October or October end, we'll start with international law. And in January approx, we'll start with constitutional law. More or less. This is a very broader design I can give you.
So sir, we will be done by February or mid-March.
Yes, February, not March, February. We'll be ending by February.
Okay, thank you.
So initially you explained about unenforceable agreements.
I've just mentioned, I haven't discussed anything as of now. We'll discuss each of it separately. But ask.
The question is, so whatever is unenforceable agreement is also a void agreement.
Not always. We'll talk about that. Not always.
So basically, for this one, like contract law.
Yes, more or less. Yes, sir. See, recorded lectures, you can see them for 30 more days. Starting from today, these will be there for you for 30 days.
From today.
From today. 30 days.
Sir, in how much time the recording is uploaded?
I think it's 3. I think it will uploaded by evening. I think
Okay.
so. Any other doubts?
Sir, I had a question.
Yeah.
Sir, during the course of, our law school days, we've consolidated notes. So, and of course, you would be giving us notes in the form of PPTs and handouts. So, is it
I'll
essential?
also provide you some dictation.
Okay, sir. So it's
that I'll-
essential for us to maintain one copy for the law optional subject per se, right, sir?
If possible, yes, definitely.
All right.
Because anyways, we'll be dealing one subject at a time.
Okay, sure, sir. Thank you, sir.
Any more doubts? Sources. You can go through Akhter Singh. You can go through Delhi University's Ashok Jain, Dukhi. Good enough. इससे ज़्यादा चाहिए नहीं. And yes, in contract from the next class, please have a Bare Act. That would be necessary. Either you can have it online or a physical handbook. I think a book would be better. Bare Act. Contract. Bangia, any basic book is good. Any basic book. Because every basic book gives you the same knowledge. Someone having more commentaries, someone having less commentaries, nothing more than that.
Sir, I want to ask, do we need to study some book for jurisprudence for law optional?
No, jurisprudence is not part of a subject. Whatever is there in terms of jurisprudential understanding, that I will deal with in the class.
Okay.
No, not at all. When we'll start, in fact, talking about jurisprudence, we'll start with international law, some elements of it, but I'll start it from there. Don't worry. I'll ask you what is the meaning of a right, RIGHT. Does right create obligation? Does right create interest? All of that, but later, not now. Because in international law, we have to understand the development of international law from a positive perspective and also from a natural law perspective. So that is something where slight jurisprudence comes in, but that's a part of your syllabus. As in nothing to study extra, anything. We'll discuss all of that in the class. That why natural law is important. What is the element of nature in natural law? Does the element of divinity also gets involved? All of those things comes later, not now. I don't want to give you any dictation on day one. Okay? I just wanted to discuss and give you a broad framework, or rather broader framework of the subject. I hope you understand the requirement of UPSC through these questions. I have not taken much questions, but based on whatever we have discussed today, right? Let me know in case you did not follow anything. Then I can again repeat it from Monday. In case if you have not followed any doubt, but please understand this, that so far we have not even started contract. It is just a mere introductory, sort of an introduction to what the different terms are, and of course, what is the requirement of UPSC in that sense. Okay, any more doubts?
Sir,
Yes,
sir, for the law students who are currently studying in law school, sir, we have our college classes also, and it may not be possible to cover the full course on live sessions. And we will rely on recordings, but sometimes there will be requirement for doubt sessions. So will you be available for doubt sessions?
No problem. We can conduct a separate class in case all of you agree on certain topics. We can have an extra class, no issues. We can take it, or you can come to me also. In case you are in Delhi, you can come to me to solve any of your doubts. No issues there.
Okay.
You can email me, contact me. I don't have any issues. Just that, let me know prior.
Okay, thank you.
And regarding doubts, in case, let's say, you are not able to understand anything, ask me there in the class itself. I'll repeat it again. I don't have any problem. Yeah, at that point itself, because I'll be asking questions. Whether you understand or you don't understand, I'll also gauge. So don't worry for that. Because I'll also make you write some of the answers. Ask to chalo theek hai, we are just starting. But in the next lectures, we'll go through some of the topics properly. like general offers, what are different types of offers, the various elements, and then we'll also try to have a sort of a structure for your answers. Could we have a WhatsApp? You can create it, no problem there. Any doubts? I hope I gave more clarity rather than giving you more complexity. Are you finding law any interesting or boring? Do it for yourself, no? In the previous batch, I think the students themselves created a group. So you can do that, no problem. You can collect all the numbers. Any other academic doubts? आज नहीं पूछना कुछ और? ठीक, next. Okay. Any other doubts, online students? Okay. See you then. See you on Monday from 1 to 3, same time. All right.
Thank you.
Thank you. I hope you have enjoyed the class. I'll try to make law as interesting as possible for all of you.